Alex here with part 101 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. Going straight into my mindset here, I was definitely dismayed, and what we are about to go into is a sanction motion from my ex's attorney. My ex had attempted to get attorney fees as a sanction a number of times prior, but this time she filed a dedicated motion on the topic rather than just including it in one of her oppositions as she did before. You know, I could go into all sorts of different details on why this upset me, but really what it comes down to is, at the time, I assumed that what my ex's attorney was putting into that document was what she actually felt. I assumed that what the attorneys did in these cases was actually try to facilitate what the best interests of the child were. In reality, here I am all these years later, I know now that she could care less what the truth actually was. And I'm not trying to say this to be cynical. I think sometimes I make these comments and people think I'm cynical. Guys, the tone here is matter of fact. It goes back to the fact that this is a business. These attorneys are operating businesses. They don't, I don't want to say they want, I don't think they care to take these things personal. They understand that we do. It's our kids. We aren't attorneys. We're not part of the business model. We're, in a sense, the victims that go through the business model that they've set up for themselves. But it's a simple situation. It's win at all costs. And one of the things that she can do to win at all costs is to try to financially cripple me. And in the end, that's what I talk about in the video, win at all costs, and that's what the goal is for these attorneys. And that's also why people hire these attorneys. I talk about that in the video, win at all costs. People pay thousands of dollars to their attorney to win the case. Whatever they have to do to win that case, it's all on the table. And part of that is, and I talk about this in the video, defend against attorney fees, part of that is trying to break your financial back so that you're not able to fight back. In my naive mind, I thought, I'm not fighting for fun. I'm not trying to harass my ex. I'm not trying to raise her attorney fees. I'm not trying to annoy my ex's attorney. I'm actually trying to protect my child. And so to see things like this come through really upset me because I thought that I was being misunderstood. Later on, I realized I wasn't being misunderstood at all. They just didn't care. And that's because she wasn't my attorney. My ex didn't care what I was trying to do. She wanted to win the case. Whether it caused our child abuse and neglect didn't matter to her. And my ex's attorney didn't care about that either because she wasn't hired by me. She was hired by my ex. She was essentially the legal tool, the legal weapon. I mean, some people refer to them as mercenaries, and for the most part, I hate to use that term because it has a pejorative connotation to it. And again, sometimes it can come off as a cynical response for me. But guys, here, the tone is matter of fact as well. They are mercenaries. They fight for whoever pays. That's the business model. I feel like no matter how many times I try and make it clear that my tone here is matter of fact, some of these things sound so dark that it's almost impossible for them to come off as matter of fact. Like, these things have to come off as hyperbole or exaggeration, and it's not. It's just the way it is. And I think what helps me understand the legal system now, and what helped me eventually get through the legal system, is coming to the reality of the situation. The sad thing here is a lot of people will come to the reality of the situation and they'll think, well, I'm just going to give up. This is a system that wasn't designed to do good. And so I'm just going to quit. And it is a really dark reality that we kind of have to accept when it comes to protecting our children. But the fact of the matter is, you can win. You end up having to resort to a lot of the techniques that they do. That doesn't necessarily mean you have to fight fire with fire, but you do have to embrace this idea that you're going to resolve this situation through the use of force. legal force. You're going to resolve the situation through the use of control. In fact, please watch my video, Control. And it's crazy because these are the things that a lot of these high conflict exes use. They're very controlling people. But I mean, definitely watch those videos because I'm really touching barely on the surface of a lot of these issues that I'm explaining to you guys right now in this video. Both the control video and the win at all costs videos are must watches. Anyway, you can win. I mean, I was able to do it, and it's just, you just have to embrace the really, really ugly truth so that your ex and your ex's attorney's actions stop shocking you. They will annoy you, they will irritate you, but they will stop freaking you out. They'll stop shocking you because you'll be able to predict them. You won't think to yourself, oh, what is wrong with that lawyer? Doesn't she know I'm trying to help my kids? You'll think to yourself, well, of course she's trying to do these things. Of course, that's how the system is, and here's how I'm going to fight it. Because you were prepared for their sort of ruthless approach to litigation, instead of being shocked and freaked out, you're able to sort of take your own, I hate to say it, ruthless countermeasure. And in the end, I've talked about this in a number of videos, in the end, a child who's being abused and neglected by a high conflict ex needs you to win the case. That's the really harsh, ugly truth, because the high conflict ex won't agree because it's going to end the conflict. So if the conflict isn't going to end voluntarily, then the only other way for you to end the conflict in a way that protects your child is to win the conflict, which is all of the things that they tell us not to do, which you shouldn't do in a case with two normal human beings who love their child, but counterintuitively you have to do in these types of cases with high conflict exes. Anyway, I think at this point in time we can go ahead and take a look at what my ex's attorney has filed. Here we have my ex's attorney's motion for Rule 11 sanctions. I want to talk a little bit about what this is. Actually, I'll wait till I get down to the actual citation to the rule before I actually do that. So, standard introductory paragraph by my ex's attorney indicating that her client is appearing through and by her, the attorney, and she should be mentioning that her client is the respondent. They usually will mention that in the introductory paragraph. I also noticed that she identifies myself as the plaintiff and my ex as the defendant, but this is not a divorce action. This is a petition for child custody, and so I'm actually the petitioner and my ex is the respondent. A lot of times these attorneys will have a paralegal prepare these documents from like a form, and they won't update these little details, and so it'll look a little bit weird, but that's typically why they ended up doing that. It's unlikely that she typed these things out. It's more likely that she didn't just backspace and replace these with the correct terms. Going into the points and authorities, we have a factual background, probably going to be a standard introductory paragraph on the factual background. April 20th, 2009, review hearing was scheduled, in-camera review of the mental health records. It's crazy here because they're trying to punish me for getting these mental health records into court, which is like even more off the reservation. I mean, it's already off the reservation to deny that request. It's even further off the reservation to actually ask for attorney fees as if I'm trying to harass everyone. It's like, that's taking it a step further. That's saying not only am I wrong on applying the law, that's saying that I knew I was wrong and I purposely filed it anyway just to cause them issues. So anyway, they're basically leading into what brings this motion. Next paragraph here is that I emailed my ex's attorney, told her I was going to file a motion. She emailed me back asking what I intended to file. I responded that I filed a notice of intent and that I was thinking of getting primary physical custody, and that looks like the end of this paragraph. Next here we have my ex's attorney stating that she's open to a proposal so as to avoid motion practice, and then a week later without any notice to her. This is the part that really infuriates me. I wish she would have tried this to another attorney, because the attorney would be like, who the heck do you think you are? I don't have to give you notice that I'm going to file a motion. In fact, if I had hired an attorney, she wouldn't have even put that in there because she would have been ridiculed. But here I am, a non-attorney, and so she's almost trying to create this I feel like what she's trying to do is exploit the judge's misunderstanding as to the role of an attorney. This specific judge kind of thinks of other lawyers as mini judges, as a judge before the judge. And so in this sense, she's exploiting his wrong-headed approach to attorneys and understanding attorneys in child custody cases. And by exploiting that, she's basically saying, hey, I'm the mini judge, I'm the judge before the judge, and this guy isn't giving me the respect of allowing him to file something. It's an absolute ludicrous approach because your opponent isn't there to allow you to do things. You're doing things against them. The only person who allows anything is the judge themselves. Anyway, but this is her just leveraging the judge's incompetence in this particular area of law. Moving into the next paragraph, we have, in conjunction with the motion to modify custody and order regarding education, I had some subpoenas issued. And moving into the next, she's also discussing my motion to have these identities of psychological providers disclosed, which we've already gone over in the series. Here we have the order denying from the court, and my ex's attorney is asking for attorney fees in the amount of $1.6 thousand because she's basically arguing that she prevailed. Rule 11 of the civil procedure, of the Nevada Rules of Civil Procedure, allows for the recovery of attorney's fees as a sanction. You're basically arguing one of two things. Number one, you are arguing that the person filed something with the intent to harass you, which requires evidentiary support. That's tough to get. Number two is you're arguing that they filed something without any, what do they call it, reasonable basis, or they also call it a groundless claim. That appears to be easier, but in a sense, it's still difficult because a lot of attorneys can claim that maybe this wasn't the law now, but I could have possibly argued that it should become the law in the Supreme Court. So they have a lot of ways to get out of that. They can do this against non-attorneys, and here's what's crazy. I would love to run the numbers on this because I strongly suspect that this is something that is done far more often than not against non-attorneys than attorneys. And I can imagine that the reason why is because judges are more likely to abuse their discretion in awarding these fees against a non-attorney than they are against an attorney. The mechanisms available to defend against these are vast. These sanction motions are pretty easy to defeat. If you want to learn more as to why, watch my video, Defend Against Attorney Fees. But a lot of non-attorneys don't know this, and so it's easier for a non-attorney to fail to raise an objection that is needed to defeat these motions, and therefore it's easier for an attorney like this to get these fees against a non-attorney, even though under the law they wouldn't ordinarily be entitled to them, because not so much because what they're arguing for is correct, it's much more that they're expecting their opponent, who's a non-lawyer, to not know what the heck to do to block it. Anyway, I want to mention something now that is really upsetting to me. This rule has what they call a safe harbor provision, and I did not know this at the time. Had I known this, I could have easily defeated this motion, and the reason why is because this attorney did not comply with the safe harbor provision. It really, really upsets me because if this happened to me, most likely lawyers like this are doing this to thousands of people without attorneys, and they're abusing this lack of knowledge of the non-lawyer to get these sanction motions granted in some of these cases. The safe harbor provision is clear, and it actually comes from the Federal Rules of Civil Procedure. It comes from FRCP 11. I don't know if the federal rules still have the safe harbor provision, but Nevada does. It has not been removed. There are some districts in Nevada where you can get around that, and in fact, it might only be one district. It's District 8, Clark County, and that's because they have some local rules that don't require you to comply with the safe harbor provision. But in Nevada, all the other districts I don't think have that local rule, and so they have to fall back on the Rules of Civil Procedure, which is the sort of blanket overarching rule system. Anyway, the safe harbor provision works like this. Before you ask for the relief, you have to give your opponent an opportunity to withdraw their request. That basically is them, returning to safe harbor. It gives them an opportunity to retreat. And if your opponent does not do that, then you can file this motion and ask for the relief for the sanctions. But if your opponent does do that, then that's it, it's over. You can't recover attorney fees. That's how the safe harbor provision works. It basically requires the attorney to provide a copy of the motion for sanctions prior to filing it, and and there's like a certain amount of time for them to withdraw that motion. I think it's 10 or 11 days. I think they can do it not just for motions, but for the complaint itself. There's all kinds of other things. Anyway, I'm going to take a look at the citation here to see if the provision is included in this copy paste. Representations of the court, representing to the court, let's see here, subsection 1, not 2, claims, defenses, 3, allegations, 4, denials, sanctions, if the notice that's violent. Let's see here, if warranted, the court can award to, okay, so it looks like she's left it out. That is interesting. I'm going to go ahead and see if I can pull that up and edit it into this video. So I'm going to go ahead and stop at this point and edit that portion in. And as promised, I have opened up Rule 11 very quickly. Here you can see Rule 11, signing, pleadings, motions, blah, blah, blah. Rule 11, sanctions, is it falls under subsection C here. And here under subsection C2, you can see the procedure. A motion for sanctions must be made separately from any other motion and must describe the specific conduct that allegedly violates Rule 11. The motion must be served under Rule 5. However, it may not be filed or presented to the court if the challenged paper, claim, defense, contention, or denial is withdrawn or appropriately corrected within 21 days after service. So, as you can see here, she did not comply with this rule. She did not comply with the safe harbor provision. She waited until after denial to serve the motion. She didn't give me an opportunity to withdraw it in compliance with subsection C2. If I had raised this argument on opposition, I would have instantly defeated that motion. If the judge went over my objection and entered sanctions against me in violation of the plain language of this rule, I could have filed an appeal, and I am 99.9% sure that the Court of Appeals or Supreme Court of Nevada would have overturned his decision. I have won these appeals before, but it doesn't happen until later in the case when I get more savvy, when I understand how statutory construction works. And unfortunately, this is too early in the case. I didn't have the experience or the knowledge then that I have now. So I do not appeal this decision. And in fact, I do accept the deal. It's a deep discount that I accept, but we'll go ahead and talk about that more when it actually happens in the case. Let's go ahead and move on at this point. And I'm back now after having shown you guys the portion of the rule that she left out. And we're going to go ahead and move on at this point. Scrolling down, we have 16.21, which discusses that we cannot conduct post-judgment discovery in demand. Okay, so this is the rule that my ex's attorney and I had that disagreement on. She felt that there should be a step before the step where I file some kind of request before I conduct discovery. Whereas I felt that the motion to ask her to disclose who those providers were, I felt that that motion in and of itself was in compliance with 16.21. I didn't think that there should be a second middle step in that process. Had I received this sanction motion consistent with the rules as required, most likely I would have erred on the side of caution, withdrawn my motion, asked then at that point in time for that's, I could have basically filed a dedicated 16.21 motion as the attorney wanted and then gotten it taken care of in that manner. I still think that the judge would have denied that anyway. And it still would have been appealable, in my opinion, a very strong case for appeal. But at the very least, I would have dodged a bullet on this request for attorney fees that my ex's attorney was filing here. Of course, she didn't do that. She waited until the motion was denied and filed this request after the fact. Do I think my ex's attorney knows about the safe harbor provision? Yes. She's been an attorney for a very long time. I'm sure that other attorneys out there have used Rule 11 appropriately with her. I'm sure she knows how it works. I think that she, knowing how the rule works, deliberately violated the rule, crossing her fingers and hoping that I wouldn't know how the rule works so that she could exploit my ignorance as a non-attorney. That's my opinion. The alternative is actually worse. The alternative is that she didn't have a clue how the law applies, and she just ignorantly, not knowing, asked for Rule 11 sanctions. This is very unlikely. She was an attorney who I think had been practicing at least 10 years at the time that she was litigating this case. So very, very strong reasons as to why she most likely knew how the safe harbor provision worked and then just abused it by just hoping I wouldn't know how it worked. Scrolling further, we have next assertion here, which is, these are the res judicata citations that I already discussed. This is McMonigal, so I'm not going to cover them again. My claim for privilege under the statute is denied by the court because the proceedings are not... She's taken advantage of the judge's erroneous. Okay, so I talked about this as well, and she's basically leveraging the judge's. So what she's doing, she probably knows he's wrong, but there's nothing stopping her from using that against him. And this is the ironic thing about these attorneys. They don't just use your mistakes against you, they will use the court's mistakes against you as well. So I'm laughing here because she knows that this isn't how the statute works, but she's using it against me because the judge thinks that that's how the statute works. And I've already talked about this in a previous video. There's a strong chance that the judge wouldn't actually do this against any other case, against any other attorney. But I think that this judge in this particular case is also exercising what I call self-representation bias. If you take a look at the video, self-representation bias, you can get into some of the details there as to what's going on. At the time that I filed my various motions seeking information, I knew that the court already considered her mental health issues. Okay, so these are the res judicata arguments that I already discussed prior. I went into these in great detail, so I'm going to avoid going into them again. Conclusion, she's respectfully requesting that my ex get a full Rule 11 attorney fee sanction award. I will explain this, guys. The judge gives me a massive discount on these sanctions, and I think that that is because he also knows that an order entered over my objection would likely be overturned on appeal. So by leveraging the settlement and by giving me a deep discount on what my ex is requesting, he ends up dodging that bullet because anything that you agree to is not appealable. When you agree to something in court, when you stipulate to it, you waive your right to appeal because you're not objecting, and you're not objecting to that. You are actually embracing the proposal. Scrolling further down. And we have just a conclusion. Next page, we have the affidavit by the attorney. Is this supposed to be in compliance with Brunzel? It might be. This might be, I don't think so. I don't think this is in compliance with the Brunzel factors. So this might come back to bite her. If you want to know more about that, we're going to go ahead and wait till that comes up in the case because the Brunzel factors do come up at least once, maybe twice in this case. And that'll give me the best opportunity to discuss how exactly those work. They have to do with how attorneys recover attorney fees in these cases. We got the certificate of service by mailing indicating that my ex's attorney mailed this document to me, and let's see when the date was mailed. So December 6, 2012. So this right here supports the fact that she didn't comply with the safe harbor provision. Not that I think she would have lied. I think if I confronted her on it, she would have admitted it. And at that point in time, she would have been totally destroyed because of the plain language rule. If you want to know more about why the plain language rule is so powerful, watch my video, Statutory Construction. There are certain principles in statutory construction that the court cannot bend. And one of those is the plain language rule, which is discussed in that video. Moving here down to the next paragraph, we have the... this is the motion opposition notice. Based on the check marks in these boxes, my ex's attorney does not have to pay a $25 filing fee to file this motion. We have the index of exhibits. We have exhibit number 1 and exhibit number 2. I know that I've gone over exhibit number 1, so I'm going to skip over that, but I haven't gone over exhibit number 2. As with my previous videos, anytime I cover a video in the anytime I cover a document in the My Docket series, and it comes up again, I will skip over it. But if you look down in the description below, you'll see a bunch of links. You'll be able to click on those links to download these documents for yourself. You can review them for yourself. And if you have any questions on a portion that I've skipped over, you can always mention it down in the comments below and I'll discuss it. Exhibit 1 with the email that I've already gone over in a previous video. And then we have exhibit 2 here with the invoice that she sent my ex. I'm just curious about this. Let's see what it says. So we have, so it looks like she blanked out the portions of it that are not in controversy. So she charged my ex 1 hour to draft the motion to quash. I wonder if I computed this at 1 hour when we went over it. I doubt I did. So it's interesting to know what she's actually billing my ex in some of these documents. I feel like an hour is kind of high. It looked like mostly a copy paste. We got the ex parte motion to quash, which is another hour. Definitely, I think that's too high. That was mostly recycled case law. Here we have the reply to opposition. Again, recycled case law and a copy paste. I highly doubt that this was 2 hours worth of work. More likely, probably around a half hour. Opposition, same thing. Copy paste document with recycled case law. So yeah, these amounts are. If we go based on these amounts, then my exes probably spent more like double or maybe not triple, probably 2 or 2.5 times what I am showing her costs and attorney fees to be in the aftermath. So just kind of looking at these charges and look at this. Here we have a telephone conference with my ex's attorney. between my ex and her attorney at 75. So three-quarters of an hour. It sounds reasonable, but it sure isn't what I've been computing in the aftermath. So yeah, guys, you could take the amounts in the aftermath, and I think if you double those amounts, you're probably closer to what my ex is actually paid, or actually owed. I don't know if she's paid those amounts. For sure, those are the amounts that she owes. I'm going to stick with the conservative approach that I've taken, but this is just kind of something to keep in the back of our mind as to what's more likely the costs and attorney fees that she's, incurred at this point in time in the case, and going forward as well. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. My ex's attorney filed one motion. I do think that this motion sort of unravels a new area of case law that my ex's attorney hasn't discussed. She usually just cites this list of statutes to try and recover these fees and costs, but this time she's trying to use Rule 11. It's different. There's a little bit of different law. I don't think it's reasonable to put it at an hour, but I think a half hour does make some sense. So actually, did I cover costs yet? Well, we'll go ahead and cover the attorney fees. At the rate of $250 an hour, that's going to come to $125 in attorney fees for my ex. She did file that one document, but it's a free filing, so she incurred $0 in costs. And I did file, and I didn't have an attorney, so I incurred $0 in attorney fees. All that being said, if you have any questions, as with my previous videos, feel free to post it down in the comments below, and I will see you guys next time.